Yes.
Adjournment request from item number 1 to 9.
Very clear. Item number 6 has become instruction, so I'm the that it can close the instruction.
Item number 6
Yes.
is Potowari. Mr. J. Potowari, learned advocate for the petitioner, submits that this writ petition has become infructuous, dismissed as having become infructuous.
Wait, please, Mr. Lawson, my lord. In item number 10, my lord, I have filed an affidavit, my lord. Kindly call for my lord.
Item number 10,
My lord.
9 and 10 are together.
10 relocation.
Okay, as straightforward. Your
Call for the affidavit, my
I
lord.
want to call for the affidavit.
call you wants to call for the call it.
Okay.
Copy that.
Item number 11 to 19. Adjournment request.
Please, Lordship, I beg to mention item number 18, your Lord.
Yes,
Lordship, I'm for the respondent number 10 to 11.
a general slip has been submitted. Give him a date. Deeply open.
Item 17.
18.
Please, Mr. Lord.
In item
21st July.
17, we have circulated
21/7.
petition.
Item number
17.
Seven. Call it, sir.
And it's in the month of June, Lordship, last quarter.
See,
Possible.
I think this is.
25/6.
Deeply obliged, Lord.
From item number 20 to 25.
Item 20, my lord, there is, I remember my in-laws family, so I visit the court. Item 20 May to swallow the first and second week of June, my matter will be urgent anyway.
When you want?
Or 9th or 11th of June, my lord.
June.
why can't you do it today?
My lord,
Why can't you do it today?
I don't have to leave the court because there is bereavement in my in-laws house. Yesterday,
Bereavement, okay.
yes.
As prayed for on behalf of the appellant, re-notify some date, whichever is comfortable.
16 June,
Obliged.
20 and 21.
May it please, your Lordship. Lordship, with the consent of the other side, I beg to mention item number 24, your Lordship. Lordship, I require 3 weeks time to file my affidavit, Lordship.
You are appearing for the respondent.
Respondent number 1 and 2, your Lordship.
Respondent number 1 and 2.
Yes, sir.
All right. As prayed for on behalf of respondent number 1 and 2 and agreed to by the land council for the petitioner. This case is adjourned to your date after 3 weeks.
23rd June.
Obliged, Lordship.
From item number 26 to 32.
Madam, with the consent of the other side, I beg to mention item 26, madam, on behalf of RDB. Let this matter be come up with please, madam.
You are for the respondent.
I'm for the respondent,
I'm
Lordship.
sorry, madam. I am appearing on behalf of RDB, madam.
Can it be on 21st of May, Lordship?
As prayed for on behalf of the petitioner. Let this matter come up for consideration on 21st of May.
Obliged.
Lordship.
Any other request?
My lords, I pray for listing of a pending rate appeal, my lords.
What is it about?
My lords, matter pertains to allotment of a retail outlet dealership under the IOCL. Lordship. The petitioner was selected, then after he was not, he
When
was,
have you filed your petition?
lordship, in the year 2024. And
Tomorrow, day after tomorrow.
Yeah.
Day after.
my lords.
Any other request?
Yeah.
This is an affidavit. Yeah.
Mhm.
No affidavit after order that 5 May number affidavit.
Yes, follow.
Daily list for orders item 1.
My lord, the forest department has to file a affidavit as per the last order.
You have not filed it up till now.
My lord, we will receive our signed affidavit tomorrow, my lord. Some significant progress has been made About my lord, 940 hectares has been cleared by forest department. Will bring
18th May. Item 4, June. Item number 5, item 7,
Petitioner itself. I am not the petitioner, my lord. I am not the petitioner.
Contempt case number 2016. Let this matter come up for consideration on their.
Yeah.
Obliged.
13. Supplementary list item 33 for orders.
Lordship, may please this number.
Yes,
Lordship, the case was dismissed for default, Lordship, because the chains of counsels, your Lordship, our name was not shown, and in fact, in the cause list, your Lordship, Lordship, as
all right,
CBP
for the
says.
reasons stated, take the order. The application is restored to its original pattern.
Item 34.
Lordship, service is awaited.
Awaiting the report regarding service of notice on the respondent number.
So respondent.
On sole respondent, the matter is adjourned to solicitor. 3 weeks.
26 June. Item 11 for admission.
So also the matter is still before the mediator.
Mediator has asked for an extension.
Yes, Lordship.
Acceding to the request of the learned mediator, who could not conclude the proceedings. The time period within which mediation be concluded is extended by a further period of 8 weeks. Let this matter come up for consideration along with the report of the mediator on so and so.
5th August.
Yes, Lordship.
Item 12.
Yes.
May I please, Lordship, Lordship, the appeal is directed against the learned single judge. Whereby the learned single judge has directed the union to provide the appropriate pay scale to the petitioners in the petition. Now, before going into the order, Lordship, I would like to take your Lordship to the how they were appointed.
Just give us a minute.
Lordship.
Now, what is the office memorandum dated 4/9/2019 of the central government?
That is
Can you enforce that?
a lordship. So far as it will be equal pay for equal work.
No, no, no. It says that these casual workers also should be paid wages equivalent to 1/30th of the minimum.
I have a copy of the lordship over the report supplied
I have.
2019. And the passing on that. Oh,
But they are contractual, not casual.
they're contractual lordship.
So therefore, the central government has only been directed to reconsider the proposal of the state government.
Lordship now.
So you consider and do whatever you wish to do. Why can't you follow this? I mean, equal pay for equal work, Jagjeet Singh, we understand.
I can understand lordship now. So far as lordship is concerned, consideration, it may be positive, it may be negative, and it will be followed by an order. But lordship, the problem is with the executive lordship.
No, but reconsideration, the court has asked, why do we interfere? Court doesn't say that you grant them. Court says you reconsider, you have rejected it, reconsider it. Considering the other cases, because why do you want to keep them in a different category? Of course, Jago will not strictly apply for the reason that they are not casual. They knew about the terms of the contract.
Lordship. And there is also a case from lordship state, Bihar, state of Bihar. Lordship, if your lordship will pick it up in the next week, I'll have a word with my ministry.
It's only for consideration. I don't
Yes.
see.
No,
The learned single judge has been very careful in
that
writing.
I have understood lordship. That I have understood.
Yeah. At the as a background. We have heard Mr. R.P.D. Chaudhary led it. Led it CGC. Learned senior advocate and deputy solicitor general on behalf of the Union of India, and Mr.
B.
Chakravarti for the respondents. You represent all 306, 307.
No, 1, 2, 3, 0, 4, my lord. Only the repetition. My lord.
This appeal has been preferred by the Union of India against the judgment rendered by a learned single judge on 21/8/2025, passed in WPC number 7147 of 2023. The dispute in the present case relates to the claim of certain supporting staff engaged in the foreigners tribunals in the state of Assam, like data entry operators, copyists, peons, drivers, chowkidars, etc., who seek revision of their remuneration from a fixed pay structure to a regular scale of pay, primarily on the principles of equal pay for equal work. It may be noted here that sometimes in the year 2013, based on a judgment of Gauhati High Court, in which directions had been issued to constitute additional foreigners tribunals for expeditious disposal of cases relating to illegal migrants. A proposal was sent by the state government to the Ministry of Home Affairs for setting up additional temporary foreigners tribunals. The proposal was approved and many posts were created with a specific pay band. However, it was specifically directed that the remaining supporting staff of the tribunals, such as the respondents, would not be against any regular post, semicolon, rather they would be engaged through outsourcing and would be paid fixed remuneration. However, it appears that later, sometimes in the year 2015, an advertisement was issued for filling up certain posts of UDA cum accountants, LDAs, bench assistants, and stenographers of grade 2 and 3 who were to be appointed on regular pay scales. The supporting staff in question were expressly offered employment on a contractual basis with a fixed pay. The contention of the appellant / Union of India is that the respondents had accepted such appointments under those terms. It was in this background, next paragraph, it was in this background that the government of Assam, by the letter dated 1/8/2023, had requested the Ministry of Home Affairs to revise the pay structure of the supporting staff and give them scale pay rather than fixed pay. Citing the need for rationalization and parity. The aforementioned request, the aforementioned proposal was rejected by the Minister of Home Affairs. Presumably on the grounds that the supporting staff were engaged on a purely temporary and contractual basis against posts which were not even formally created. And therefore, they would not be entitled to any regular pay scale applicable to government servants. Opposing the aforementioned stand of the Minister of Home Affairs, the respondents preferred the writ petition before this court, bracket WPC number 7147 of 2023, claiming their entitlement for pay parity. Next, by the due judgment, the learned single judge was of the view, the learned single judge opined that rejection of such proposal of the state government required reconsideration, as it was patently unjustifiable that while certain contractual posts, while people working on certain contractual posts were granted regular pay scales, the supporting staff who have been performing essential and indispensable functions are denied similar benefits. Based on such observation, it was directed by the learned single judge that the central government ought to reconsider the proposal of the state government and to take appropriate steps for grant of scale pay to the respondents instead of fixed pay. The direction, as we understand, is for a reconsideration of the proposal of the state government. Which does not immediately require our intervention at this stage. Mr. Chaudhary, learned Deputy Solicitor General, submits that he shall take instructions in the matter and get back to this court on the next stage.
Yes.
Next day. In the meantime, the operation of the judgment, reconsideration. You reconsider and tell us. No need to state this.
Well, one aspect of the matter has gone wrong, possibly, my lord. Here in this case, my lord, the petition respondents and those who were given scale were in the same selection process, same advertisement, not subsequent advertisement. The law mentioned.
Source of entry, we are not questioning.
No, what I need to submit, my lord, it is by the same advertisement. Some are given scale and some were not. It is not that they were subsequently recruited, my lord, as your lordship has mentioned in the order.
Okay.
It's the same advertisement.
All right, we'll make this.
22-6. Item 13.
The Department of Revenue has also filed appeal, which speaks on 17.6. So let us know with tag lordship.
Mr. Porpujari, my lord, you have not challenged this judgment.
Yes, we have challenged. We have challenged. There was a.
I think there will be better advice not to pursue this thing. We've got more than what perhaps the circumstances required the single judge to do. 44 years old matter. You should have been more than contented with this direction. Now we want solution and everything. We will question the very issue, the very decision of the single judge reviving the whole issue after 44 years. You don't even get that. What kind of advice do you give to your clients? I mean, if the whole thing is raked up, I think you don't deserve to be paid anything.
Point of time. Money was paid to somebody else according to them. It was received.
Yes, before the single judge, the records were produced. From the records, it transpired.
Where is
that money was
where is it listed? Your appeal?
It is fixed on 17th of June, my lord, as per its last order. Because
And,
there was a delay.
The appeal has been numbered?
My lord, not yet numbered. Delay has been condoned by 10th of.
That we see.
Yes, my lord.
But we list it along with which?
WA 1206 2026 filing number.
Filing number will not do.
Filing number would not. Tell us the number, we'll fix it on 17th of June. Anyway, we fix it on 17th. It appears that challenging the same impugned judgment, the state has also preferred an appeal, which is slated to be listed on 17th of June. Stop. Let this matter also be listed on 17th of June, along with the same writ appeal, along with the appeal preferred by the state. Number will be taken later.
Whether if any defect is there, clear it.
Yes, my lord.
You should not have stoked this. Don't you advise this to your client? What you have got something which was more than enough. Now you want solution, you want fresh. I mean, the whole issue is, see, the learned single judge, paid that after 44 or 50 years of the entire process by only saying that they are not coming up with definite proof that you were paid. But the register mentions your name. Now you will have to prove that you have not taken.
No, we have not received any amount.
So that will not be decided in writ jurisdiction.
Item 14.
I'm so obliged.
Yes.
Instructions the petitioner is entitled to the DA and whether that has been paid to him.
Not DA.
Yes, DA. 11th of February, order lordship kindly come to. 11th to 2020.
Daily allowance.
Yes,
DNS, not DNS.
Sorry,
Daily
daily
allowance.
allowance.
DA is
Sorry.
DNS allowance.
I'm sorry. Daily allowance. I have received instructions from him which says, yes, some amount has been paid to him. Whatever he had claimed, that has been paid to him.
Give a copy to him.
Yes, I have one copy for
You'll
him.
be entitled to DA and you have been paid.
Yes.
Nothing more.
I have been instructed that only for 10 days they have paid. Around 3 years, as he worked, he received.
That would be a separate subject matter. Once they have acknowledged that you are entitled to DA, then you may file another case, another representation that you require daily allowance for more number of days because you have served for 36 months. Correct?
Can this matter be taken up in next week? I'll take instruction in that matter.
Why not? Why not?
My God.
We are closing the case, therefore we'll give you one more. Otherwise, also you were never posted in Bhutan.
No.
You went and came back.
Yes.
Therefore, you would be entitled only to the daily allowance.
Yes.
Correct. So take instructions by next week.
Mine.
Here. You will do this. By order dated 11/2/2026, this court had asked Mr. M.R. Adhikari, learned counsel representing the respondents, whether the appellant was entitled to daily allowance and whether it was paid to him on account of his having worked as a driver, taking the government vehicle to Bhutan intermittently. Stop. The claim of the appellant was for payment of Bhutan compensatory allowance, which was not acceptable to the respondents for the reason of the appellant not having been posted permanently at Bhutan at any point of time. So, Mr. Adhikari, on instruction, submits that whatever daily allowance was to which the appellant was entitled has been paid to him. Mr. Saikel and his advocate for the appellant seek some time to take instructions on the matter before pressing this case any further. Let this matter come up for consideration for so and so day. After 1 week.
June. Item 15.
Yes. We don't want to dismiss this case. Otherwise also you have been very harsh to him. Though he doesn't, he can't claim it as a matter of right now. After 24, after how many years? 2014, 26 years.
Yes, Lord.
No, after 24, that's what, you know. What is that?
11 years.
But then the way you have treated him,
Immediately.
it was not because of his fault.
Yes.
Again, nobody appears on behalf of the felon. He must have seen our judgment.
Devrata.
Devvrat and our judgment also.
Yes,
Based on Devvrat and other cases.
That's it.
We'll do it in his presence, not in his absence. Nobody appears on behalf of the appellant to request this. He, the counsel for the respondent, however, is present. Let this come with a consideration after 3 weeks.
17.6. Item 16.
Lordship, here in this matter, we have just received our affidavit. Lordship, we have served them a copy. Lordship, it will be filed in the course of the.
Higher Education Department.
Yes, Lordship.
It takes 5 days for you to take instructions and five next dates for filing your counter affidavit. Huh? We find it's continuing since long, since the days of Honorable Justice Bisnoy. As great for, but that is the last opportunity to you.
Lordship, we will file it during the course.
You are filing it today.
I am filing it today, Lordship. We have served them a copy. Yes, Lordship.
The letters, your standing counsel education.
Yes, Lordship. Appearing for 1, 2, and 4, Lordship.
The letter counsel appearing for response number 1, 2, and 4. 1 to 4 submits that the requisite reply affidavit is going to be filed in the registry today. So in that case, let this matter come up for consideration on give a date after 4 weeks. It is expected that the copy of the reply affidavit shall be served upon the counsel for the petitioner today.
Already, sir.
You already, it appears that the advance copy of the reply affidavit has already been served upon the counsel for the petition. He may, the counsel for the petitioner may also rejoin in case so deemed necessary on or before the next date. 3 weeks, 4 weeks.
22nd July. Item 19.
May please remember. Well, pursuant to 30 years of unblemished service, Constable Prem Kumar Singh was removed from service.
Pursuant to your 30 years of service.
Yes.
It is despite your 30 years of service. Pursuant to service, I mean, you were dismissed on the ground of remaining inebriated in court.
Removed.
When
Removed.
you were removed. Now don't say pursuant to remaining in
Well,
service of 34 years.
It was
As if
just,
for remaining in service, you have been
no, it
removed.
was just one solitary incident, Malaj.
Maybe.
Malaj, the judgment which is under challenge is the judgment dated 7/1/2025. When the matter was argued before the Honorable Single Judge, Malaj, it was not pressed that he should be acquitted or exonerated, Malaj. It was only prayed, Malaj, that since considering his 30 years of service and also considering that it was only a solitary incident, Malaj, that removal should be reduced to compulsory retirement. Now, in that case, Malaj, at least the retirement benefits are payable to the appellant.
How do you say that it was not pressed?
Yes, Malaj.
Paragraph 15 of the judgment.
Yes. I'll directly come, my lords, to the grounds, my lords, the grounds of assailing the judgment by the honorable.
Grounds we are not asking for. You may take several grounds.
Yes,
You may take single ground.
yes,
Doesn't matter.
yes,
When the decision of an administrator,
yes,
decision of an executive authority is under challenge,
right, my lord.
all aspects are gone into. The
Yes.
court says that there was no breach of rules. There was no
Yes.
breach of principles of natural justice. You were given all opportunities. Now, there were many witnesses who were examined.
Yes,
The witnesses have confirmed that you had consumed liquor
Yeah.
while on
I have
your
admitted,
duty to
I
carry-
admitted, my lord.
Correct. Now, whether it was a solitary incident or it was a repeated thing was not the subject matter of inquiry.
My lord.
Correct.
Very true.
On that
Very
day,
true.
you were found sleeping on the bench. And then another witness, which is not part of your charge, if we are correct.
Yes, not part of the
If
charge.
they are not
It was not
part of-
considered by the inquiry officer also.
You
That
also-
is not correct.
you
That is
also
not correct.
try to misbehave
No,
with
that
the
is not
woman.
correct, madam. So that's unsubstantiated. It's not even a part of the charge. madam.
Correct, but this has been observed by the court
Right, right,
from the records,
right.
but this
Right.
has not gone into the decision making. So he has not been influenced. Where do you ask us to interfere? How?
My lord, I'll just.
What is this proportionality thing?
Yes. Yes, proportionality, my lord. First, my lord, the first what I would like to submit, my lord. The honorable single judge failed to weigh certain mandatory factors, my lord. The first being, my lord, that he had given 30 years of his service, my lord, to the service to the police force, my lord. And secondly, my lord, he had admitted that during that time, my lord, there were certain psychological issues, my lord. His daughter was about to get married and his sister-in-law had expired. And secondly, my lord, I'll come to the main.
That's no justification.
And secondly,
It's not justification for consuming liquor while on.
exactly. And secondly, my lord, secondly,
It may not be. It may not
on
be
merits, on
morally
merits,
wrong or something.
on merits, my lord, on merits, the impugned order of removal itself is perverse, my lord.
Right?
That was never argued before the learned single judge. If my lord may kindly come to the charge memo for a moment, my lord, just for a moment, page 65. Page 65, kindly, my lord. What was the consideration? Lordship may kindly see, my lord. Page 65, my lord. 65, the charge memo. One single charge. And what was the charge, my lord, would kindly peruse. Just 3 documents I'll show, my lord. The second paragraph, the 4th line, you appeared in intoxicated condition on duty and created an unpleasant situation at the court premises. That was the only charge, my lord. If my lord comes to the inquiry report, what did the inquiry officer hold, my lord? Page 72. Page 72. Well, I won't trouble my lord by reading the entire inquiry report, my lord. The inquiry officer only held that it was proved that he was intoxicated on that day and nothing else. Now, my lord would come to the.
Look at your explanation. You think that would have swayed and that would have been treated mercifully?
My lord, kindly.
You say that you have consumed.
Yes. Now, my lord would come to the impugned order, my lord. Impugned order, if my lord comes to the impugned order at page 75. Impugned order, my lord has it at page 75. Page 75, the impugned order, my lord.
Now we are.
Yes, third paragraph, kindly, my lord.
He was definitely unfortunate.
On the ground of perversity, my lord. Page 75, the impugned order, third paragraph. I have shown, my lords, the allegation, the charge, thereafter the inquiry report, and what was held by the disciplinary authority, my lord, kindly see, my lord. It's totally perverse, my lord. Paragraph 3, whereas by engaging in drunken brawl, that was never the allegation, that was never the finding of the learned single judge.
Say the word.
No, drunken brawl cannot be equated with someone who's intoxicated, man. There's a difference, man. A person being intoxicated and behaving.
He meant in a state of drunkenness. He meant in a state of stupor.
Manners would not impute, manners is clear, manners. Drunken brawl would need something higher than
That's not going to get
intoxicated.
sentence reduced.
And my lord, if discipline.
We have our own difficulties, you know.
Yes.
To truly appreciate.
Yes.
Someday or the other, somebody is a person who can hold his drinks. Can perhaps go back.
The discipline force, my lord, after all.
We understand that. We are very sympathetic to him, but the law does not show any sympathy to such police constable. Or for that matter, anybody who is in uniform.
Exactly, discipline force.
And what would have happened if the under trial prisoner would have run away?
Exactly.
Or would have
that was precisely what was considered by the learned single judge.
And used it. We don't know. But
if doctrine of proportionality cannot come in the way of maintaining discipline, because what is the objective, my lord? Now he could have been given the penalty of compulsory retirement, my lord. It would have served the same purpose, my lord. He would have been out of service. And my lord, my lord would remember a judgment authored by my lord, Sangeeta Rani, my lord.
You can't.
There, my lord, lordship has considered the service, my lord, the years of service, and also, my lord.
Let us see where have I gone wrong.
Not gone wrong, my lord.
Let's see. We try and
Necessity of author judgment, my lord, then they have, my lord, would come to directly paragraphs, my lord, 33 onwards, my lord. Paragraph 33. my lord. We therefore are not in agreement with the final outcome of the departmental proceeding of the petitioner. The punishment awarded to her is much too harsh, even for the recklessness having been exhibited by her as a judicial officer. Here, there was allegations of corruption, my lord. We have also examined the issue from another angle. Compulsory retirement is one of the major punishments provided under the rules in a departmental proceedings, in which fixing the quantum of punishment is within the discretion of the disciplinary authority. However, for such decision to be sustained, the sentence should not be vindictive or unduly harsh. If the choice of sentence imposed upon a proceeding, sorry. I'm relying on Sangeeta Rani, madam, and there's another
Sangeeta Rani.
Yes.
That's a different circumstance.
One more judgment.
Look at
Supreme Court, madam.
what was the recklessness?
She was charged, my lord, with corruption, my lord, by while passing an order under 138 that she had passed it due to extraneous consideration, my lord.
No, therefore we said that it may have been indicative of lack of absolute intent.
In fact, the appellate authority was the committee, the administrative side, my lord, the High Court, my lord. It had affirmed, my lord, the order passed by the disciplinary authority.
Now, paragraph 16, how can you equate the facts of this case with
Not the facts, my lord, that
police constable? Under such circumstances, it has been urged that it was only a bona fide mistake that the documents which were on record could not show this. Further been urged that merely because of this lapse on her part, no act of dishonesty or any misdemeanor could be attributed to her, reflecting badly on her judicial conduct so as to be shown the door finally. It has further been submitted that even in a quasi-judicial proceeding, like domestic inquiry, departmental proceeding, there is no place of any inference, and the finding of guilt has to be on the basis of materials brought on such proceeding. Some document was not seen and an order was passed.
Yes.
Now, judicial officers, don't they require that kind of protection? Many a times, the wrong orders could be passed, but would that
cannot be a misconduct, cannot be construed to be a misconduct.
Dismissing a person?
This another judgment of the Honorable Supreme Court under similar facts, my lord. In this case, the person belonged to the military, my lord, Pradeshik armed constabulary, and he was driving intoxicated, my lord, and there was an accident. Thereafter, the Supreme Court held, my lord, that instead of removal, he can be compulsorily retired. He has served the same purpose. My lordship would. My lord.
Look, we have comparison was so inept. Here we have said a wrong judicial order could be modified or set aside.
Yes.
This is one of the functions of the superior courts. The legal system acknowledges the fallibility of the judges, and hence there is provision for appeals and revision. A judge tries to discharge his duties to the best of his or her capacity, but while doing so, she may err sometimes. The Supreme Court also went on to observe that every error, howsoever gross it may look, should not be attributed to improper motive. Even in cases where a particular judicial officer has been consistently passing orders, creating suspicion of judicial conduct not being wholly or partly attributable to innocent functioning. But even in such cases, the proper course of the High Court is to adopt is to make note of his conduct. A word of caution has been sounded, so and so. No greater damage can be done to the administration of justice and to the confidence of people in the judiciary than when the judges of the higher courts publicly express lack of faith in the subordinate judges for one reason or the other. It was a very different thing where for some decision under 138, which was not to the liking of the superior High Court, High Court judge, while seeing it in appeal, and an order was passed, the departmental proceeding initiated.
My lord had exercised proportionality and reduced the penalty. That's why.
Yes.
And the other judgment, my lord, Supreme Court.
And in the other case, the defense was considered, the Supreme Court considered the defense, saying that after the accident, out of fear, after parking the vehicle, He had one.
That was never proved, my lord. That was his statement, my lord. But he was nonetheless an army of military, my lord, personnel, my lord. All I'm praying is, my lord.
See, our hands are fettered. We would have reduced it to compulsory retirement, but then it will not be justified. It will not pass the scrutiny of the superior court's standards. We don't worry for that, but then it is not within the bounds of decision making.
My lord, may I kindly produce the DVD judgment once. It's similar facts, my lord. He belonged to the armed constabulary, my lord.
Okay, go beyond yesterday. I mean, last week only we have done it. We have reduced it.
Yes, and my lord, I'm only my lord, equity and some, because my lord, I've given 30 years of my service, my lord. And there's another judgment, my lord, it would serve the same purpose.
Court, no.
No, my lord is very empathic and equitable, my lord.
No,
Kindly-
you can't goad me into, being more liberal than what I should be.
No, only prayer is, my lord.
Now we feel bad. I mean, if this was a solitary instance, and then he did not show any great drunken behavior. We understand that, but then he was sleeping and the under trial prisoner was having
We
one time.
should also consider the perversity angle also, my lord.
Perversity is there is no perversity. Argue that.
My lord. Disciplinary authority was of the opinion that there was a drunken brawl, my lord, which was never part of the report.
That is the only thing that is holding us back, no?
My lord, kindly consider, my lord. this- And in the Supreme Court matter, my lord, DVD matter, removal was reduced to compulsory retirement.
That will be in.
And it was well, it would serve the same purpose, my lord. It will be out of service anyways. No? If it is for the deterrent factor, my lord, it's compulsory.
It was there.
Throughout, he did not try to defend, my lord. From the first instance, while filing the WSC, admitted that he was under some psychological stress. His sister-in-law had expired and his daughter's marriage was on the way, my lord. And the GPF money was not released to him.
Admission.
Admission.
He has admitted it.
Admitted.
We can't.
Admittedly, my lord, but that's why I'm not on the aspect of how a person has to be tested for intoxication. The medical examination only say that smell was coming out, but that's not the proper test. It was
If he is convicted for that, I think you'll have some ground. That merely on the basis of a
Yes,
analyzer
blood test
that
is
will be no
mandatory.
evidence. But here, the departmental proceeding, nothing was.
But that's why, my lord, from the first instance, even before the learned single judgment, we did not pray for reinstatement, my lord. There's hardly 1 year of service left, my lord. I'm not praying for, my lord, just for reduction. It has been done, my lord. In all the three judgments, my lord, penalty has been reduced. The third judgment also, Delhi High Court, my lord. There it has been observed, my lord, if it is for deterrence, even compulsory retirement would serve the same purpose. And in that case, it was a case of a CRPF Jawan, my lord, constable, and he was intoxicated during duty, my lord. Brijesh, the third judgment is ex Havaldar C. Rajinder Singh versus Union of India. It's a division bench judgment, my lord, Delhi High Court.
These are no avail. We are aware of that.
Yes. I'm so sorry, I'm just.
We keep in our minds judgments of two cases, Ranjit Thakur and on the issue of proportionality.
Yes.
Are there gaps?
Ranjit Thakur and
Are Ganathum.
Guna Yutham. Yes. Oh, lordships are aware, my lord. I'm just praying, my lord, if it is reduced to compulsory retirement, means
You have very little chances, but
My lord, kindly consider.
considering the amount of labor that we have put in, we give you another chance to argue the case. Take up. The appellant is an unarmed branch constable of Assam Police who has been removed from service after an inquiry. The sentence imposed upon him has been upheld by a learned single judge of this court, holding that a constable in uniform, if charged for consuming liquor during the duty of carrying an under trial prisoner to court, no leniency ought to be shown to him. While assailing the aforenoted judgment, Mr. Mahanta, learned advocate for the appellant, has submitted that the disciplinary authority went beyond the charge and presumably relying on the statement of one of the witnesses during the proceeding that the appellant was found sleeping on a bench, perhaps under the stupor of induced by liquor. But opined that the appellant had shown that the appellant had displayed, the appellant had indulged in drunken brawl in court premises. Mr. Mahanta argues that this aspect has not been considered by the learned single judge while upholding the decision of the disciplinary authority and the appellate authority in sentencing the appellant. He has further submitted that 30 years of unblemished record ought to have been taken into consideration. The learned single judge, by referring to the case laws on the subject of proportionality of punishment, reiterated that normally the courts do not sit in appeal over the judgment of the administrator in a disciplinary person, except in cases where the sentence is shocking to the human concept. The learned single judge was of the view that a person in uniform, while undertaking a sensitive duty of carrying an under trial prisoner to a court premise, cannot be expected to be under the influence of liquor. There is an admission of the appellant as well in his explanation that because of his mental stress on account of family reasons, he had consumed some liquor. However, while saying so, he has disputed every allegation of any drunken brawl or drunken behavior in court. Mr. Mahanta therefore argues that even if it is accepted that the appellant for a while slept on a bench outside in a court premises, forgetting his duty of being on guard till the time the under trial prisoner was taken back to the barracks, taken back to the jail. Okay, what did I say? Did not interfere with the sentence imposed upon him. The land counsel for the appellant today only presses for a reconsideration of the quantum of punishment on grounds of proportionality. On grounds of proportionality. Considering that only 1 year is left for the appellant to demit his office, to retire, that 1, 2, let who appears for the state? MS Sharma, let me counsel to the state to respond to the aforenoted argument advanced on behalf of the appellant. 325, someday we will not enter into this discussion and we'll pass an order. We are not getting persuaded.
Deeply obliged.
We are not, we think that this reference of Sangeeta Rani was uncalled for. This is from a
Only
different
for the
jurisdiction.
proportionality aspect, Malas, nothing else.
No. Judicial officer proportionality and constable drunken behavior. You should have shown other cases. I'll never be under this confusion that if this, I mean, if you bring a judgment authored by one of the judges of the bench, that is going to cut ice. And that also in a different jurisdiction. But now High Court judgments would only have persuasive value so far as we are concerned here.
Yes. Now.
24/7.
The next.
24/7. Item 22.
The lordship. Lordship was appearing from the appointment of 5 to 9. Near lordship, DM is already passed the order.
What's it?
Near lordship, DM is already passed the order.
DM has already passed the order.
DM has already passed the order.
Yes, Lord.
Yes.
Lordship, in this,
Lordship.
Give a copy to him.
the DM order is already there, but the
तो क्या करेंगे?
Insiga property has not been given possession. They have not given the position of this Insiga. And the government was to take instruction on that matter.
So what are you expecting us to do?
This order has been given
So
some back.
what do you expect us to do?
These-
Have it executed?
No,
We have
that
given
is the thing.
Nothing.
That is the thing. Only
In view of the statement made on behalf of the respondents that the district magistrate has already passed orders in terms of section 14 of the Satvesi Act 2012, there is nothing else. There is nothing else remains to be adjudicated in the bill. The petition has become infractious. Yes.
Item 23.
Yes, Mr. Naik, you are supposed to argue.
Yes, this is a case, Lordship, decided by the learned single judge, exactly on similar phase, exactly on the similar division, Lordship. And accordingly, the court said we are not required to go into merit as division bench already appealed the decision that was relied upon by the learned single. So that was the fact, Lordship. If Lordship comes to the last page of the page 139. paragraph 13 law. 139, paragraph 13.
Case,
Page 139. Paragraph 13 law.
How Ujala Nazari, we are aware of that. Mr. Nayak, in the year 2026. Well, we are telling you in the year 2026 because much water has flown down the Brahmaputra. Now, making a distinction in this manner with respect to work charged employees, even when the employment is almost permanent in nature. We know the judicial precedents we are aware of. We are aware of, but at times it creates, such gaps that, it's always a pick and choose. Now, the family pension was not being given to persons. Look at this, a very proactive approach had to be adopted. I'm not asking you to do that. We will decide it. We are not asking you. I'm just telling you for knowledge sake. In the state of Bihar, there were many work charge employments because of the construction of dams and many projects and other things. And they were of permanent nature. Many times people used to, die in harness. The employed, they were working for 20 years, 25 years, 30 years, they died. But no fixed scale. And then some of the widows were granted family pension, others were not because it was a work charge establishment. They said that they are not entitled to anything for the reason that they don't get paid from the consolidated fund. They don't get paid. It's a separate contingency fund on which payments were made. So we thought that something has to be done. You can't pay compensation to few widows and deny it to the others. So we said that till the time the legislature comes up with a law, let us at least legislate of that aspect. There was a full bench decision against the line of thinking of ours. But somehow the other, we passed, there was a division bench judgment. We made a full bench judgment. It is the name of the judgment is Mobina Khatun versus State of Bihar.
I have a copy of the judgment, Lordship. In that
Thereafter, so I was part of that full bench. State government came up with a legislation adopting whatever we had stated.
Lordship.
It was not challenged, it was adopted, and a legislation came forth. If you could kindly go through that. We are not suggesting that we are going to pass an order of that kind.
Lordship, in this judgment passed by your Lordship, one paragraph 54, therein your Lordship has held that legally they are not entitled to any benefit. Lordship.
So they have given it on equity.
Yes, my submission, Lordship.
Equity begins where the law ends.
Only submission will be, Lordship. A thing which is not legally permissible, whether equity discretion will apply there.
Enforceable. We have to consider it. See, the difficulty is that it's very easy for the parties to claim. It is very easy for the state to say that no. But then look at the difficulty of the court deciding the matter, especially after the death of the employee. It is not for any enrichment. It is not for any growth. This is for the sustenance. And you're a model employer. All legal aspects we are aware of. We know all the judgments. They're starting from Jaswant Singh and all. We understand that.
Otherwise, Lordship.
You give your written arguments. We wish to conclude it. See, there is nothing wrong in your argument. We are not taking it amiss. But it will only settle the law forever. Get it tested. Otherwise, it becomes very difficult. How do we decide? It has got nothing to do with the counsel, or his case. We are on the generality of law.
I am aware, Lordship, the judgments passed by the learned Supreme Court, Lordship. But in one particular case,
Judgments, property of vigor, they don't apply to the facts of your case. Those are because of casual appraisal. We are aware.
yes, we're daily wages.
It's very difficult to make that distinction. No, that distinction should have some rationale. You do it to casual, you don't do it to work charges who are almost similar to permanent appointments.
No, there are distinctions, Lordship. Here, Lordship, works are in place. They receive everything except pension.
Kitna din? Suppose 10 years project would go. These projects go for
So they
25 years, 60
Lordship,
years.
they all retire at the age of 60. They work till 60.
They work.
Yes.
So then after that, whether pension is required, it's the law. I think instead of asking and depending upon the court's decisions, you should come up with a legislation. You should come up with a legislation to streamline the whole thing
Lordship,
and lessen the burden of
this
the
situation was prevailing at that point of time, Lordship. There were hundreds, thousands of workers employees were there. Even no posts were created, workers posts were created. They were engaged merely on the basis of a direction passed by the executive engineer. So that difficulty we always face, Lordship. So my submission will be, Lordship, instead of written argument, Lordship will hear this matter any date, Lordship. Lordship will hear, at least I will be able to convey my understanding of law, Lordship, on this particular point. So Lordship will see all the judgments, Lordship, already passed, Lordship. Otherwise, Lordship, it is a settled position law. Pension can be granted only by following the provisions of proof. There is no exception to that. Whatever it is, be Lordship, we may call it exploitation.
Mr. Nayak, I think you have also preferred an appeal in where concern is granted to an workers employee. Where Mr. Bothakur is in other side.
Lordship, no, state has not filed, Lordship. The other side, petitioner has filed one appeal before the Supreme Court.
No, that is different.
That is,
No, that is different. One appeal when on your behalf, our adjournment was taken. Mr. Bothakur is on the other side. I think she was there while
Just find out and tell us. We'll hear all.
Gita Borman, therein also, Lordship, the petitioner filed the appeal, not the state.
We'll hear all such matters together.
not Gita Varman. Gita Varman is Gita Varman, Mr. Bothakur is not there.
Just find out and tell us. Let this matter come up for consideration. 18th June. Here, and please collate all information about other cases and status of other.
Lordship.
Look at this. We are aware of the stock answer of the state. We are also aware of the line of judgments taken by Supreme Court. We don't find fault with your argument. The question is that some different thinking is required.
Otherwise, Lordship will think of a situation. Lordship. Yes, even if it is held at that.
You find fights or not?
No,
Nothing.
work size is not a pensionable establishment.
This is callous.
Lordship, that is the law settled by the Supreme Court. Work size are not pensionable establishment.
On 18th of June. Just inform him, 21-5.
Earlier case on 21-5.
21-5.
Item 25.
Yes. Yes. It's. Yeah, pass the model. You tell us, yes.
Yes, Lordship, on the last date, your Lordship asked the state to file an affidavit and that they will, and they are agreeing to comply with the directions of the Supreme Court regarding the matter. So,
They have they filed the affidavits or not?
no, not in that line.
Who appeared? Mr. Chandran? Where is Raki Chaudhary? He was here.
Lordships, we have already filed 3 affidavits in this particular matter, the last being filed on 21/4/26. Lordship, in that we have stated clearly about our stand on the about the current situation in Pokrajar, Lordship.
Now, why was the matter adjourned on the last date? On 25/11/2025, we have said something, no? Where is Miss Hechi? What is your state doing? Just go through their affidavits and tell us.
Lordship, those setups are mostly temporary in nature, and that is not the mandate of the Supreme.
No. They're trying to, but then for the purposes, that's a gradual step. They shall do it. And just look at their affidavit and tell us whether it suffices or not. No, we did not agree with the. We did not agree to the arguments advanced on behalf of the parties on behalf of different states that nobody up till now has come for any benefit. Now, that is not the question. In fact, if I remember correctly, it was with respect to dissemination of information regarding the entitlement.
Yes, that is
Correct.
completely.
So what have they done about it? Well, you had to remind me, this was the question that I had put on the last day.
That aspect of the matter has not been touched yet.
Call Ms. Chaudhary. Call Ms. Chaudhary will say. Yes, she will remind. Mr. Chandan, you were there.
Lordship,
What is your step?
Lordship, what in the state legal service authority has filed an affidavit, Lordship, on 20.
Yes, we are taking it seriously. We had told you that we needed, proactive steps for dissemination of information
Lordship, that respect,
to the persons participating in a trial of their entitlement as a witness.
Lordship.
Call Ms. Chaudhary, we are keeping this matter on the next date. She perhaps had an idea that day. She said she was doing something.
So far relating to state of, I think,
Complete.
now so far relating to Arunachal Bhati.
Arunachal, Lordship, there centers, three are there, Lordship. Construction of one is complete, it is handed over, and two, by March, they have told that it will be completed. Lordship,
By March of
March is-
2027.
Lordship, 26 March, Lordship, I filed an affidavit.
Very May.
27.
27.
27th of March.
No, Lordship, 26 this month, that file, no, one is completed, that is handed over.
What is the requirement? The whole state.
Lordship,
Lordship, they are out of the many districts in Arunachal.
Last, okay. And I think he was not present on last day, so we say that almost everybody is proceeding in the right direction.
Let Ms. Chaudhary come. She was here. We saw her. Okay, let this matter come up for consideration. You also see the affidavits and tell us.
Lordship.
Don't seem to remember what we say on. Achal, you was not there. After 2 weeks, ask Mr. Chaudhary to.
Yes, Lordship.
16-6.
Much obliged.
Deeply obliged.
Item 27.
Yes. Is about no.
Lordship, this petition has been preferred by the Union of India, Lordship, challenging the order of the London Tribunal by which the Tribunal directed for regularization of the service of the respondent, Lordship. Lordship, husband of the respondent was engaged only on daily wages basis as a contract worker. Lordship, find the appointment order is page 16, Lordship. Type copy is, Lordship, at page 15. Page 15, Lordship.
Just a minute.
Yeah.
Yes, sir. Paragraph 6 of the judgment of the tribunal is beyond law. Jago has no application here. She refused to appear in the written examination.
Let me submit, my lord.
Yes.
My lord, my husband was the driver of the postal department. He died in foreign service in accident, my lord, at Golbara site, my lord. Thereafter, I was appointed as GM Gram Dak village Gramin Dak Sabak, my lord, in the Borban branch office at Patsalan division, my lord. And since then, I have been working as GM, GDM SC, GDM SC. And subsequently, I was terminated from my service. Thereafter, I appealed before the CAT, before the Central Administrative Tribunal at Gauhati branch.
We have written all that in our early order.
My lord,
I don't think do you have in your possession an order dated 4th of February 2026? Passed by us.
my lord, I have to go to the grievance of the petitioner respondent, my lord. Therefore, I submit these details of the fact of the case. Lastly, my lord, I approached before the tribunal for my regularization of my service, my lord. And after perusal of the records and hearing the parties, the learned tribunal passed the
I don't think you would have
interim
argued.
judgment, my lord.
I don't think
Whereby,
Mr. Ahmed,
whereby the Central Administrative Tribunal cited some Supreme Court judgment, my lord.
some
Quotation of
Supreme
the
Court
Supreme-
judgment you're saying, that is the basis. Jago. Mr. Ahmed, can you look at me for a minute?
My lord,
Can you read the order dated 4th of February 2026 passed by us when the matter was heard and we directed for issuance of notice to you?
I have submitted them, my lord, the affidavit in opposition, my lord. I have submitted already the affidavit in opposition.
24. Page. Consider the case, Mr. Chakravarti. Consider it. You can deny it. Matter has been remitted. That's what we have said. I don't know whether even if he has a copy of the order, we have got it served upon it. Internal page 4 of the order, padhiye, Mr. Ahmed. You look absolutely guileless. Mr. Chakravarti has contended that though the matter has been referred to the authorities for a final consideration, but the observations made in the judgment are heavily loaded in favor of the respondent and against the authority, which could be misconstrued to mean that there is a direction for regularizing the services. No, it will not be. Let's go clarify. Mr. Ahmed,
My lord,
Chakravarti,
I shift my affidavit in opposition page 7, my lord. Seventy-seven. Case 77, man. Have you seen? Case 77, paragraph E, man. This order was passed by this honorable tribunal in the light of the decision of the honorable apex court in the case of Jaggu versus Union of India arising out of SLPC of 11/086 of 2024 dated 2012-2004 2024 as follows. 26 para of the decision. While the judgment in Umadevi Supra sought to curtail the case of breakthrough and ensure an appointment adhere to the constitutional principles, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claims of long service employees. This judgment aimed to distinguish between illegal and irregular appointments. It categorically held that employees in regular appointments who were engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as a non-time measure. However, the laudable intent of judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of the employees, even in cases where their appointments are not illegal, but merely lack adherence to procedural formalities. Government departments often cite the judgment of Umadevi Supra to argue that no vested right to regularization exists for temporary employees. Overlooking the judgment, explicit acknowledgement of cases where regularization is appropriate. This selective application distorts the judgment spirit and purpose, effectively weaponizing it against employees who have rendered indispensable services over decades. My lord, I have been working more than 10 years, my lord, in the department, my lord. I only seeking for regularization of my service, my lord. But the department is denied, always denied my claims, my lord. And file this petition against the order of the tribunal, my lord.
Mr. Chakravarti, let your department consider.
Lordship, as per law, Lordship.
As per law,
Otherwise, nowadays it is online mode. Everybody has to apply online and the system will pick it up, Lordship.
Mr. P. Chakravarti, learned sending government for the Union of India. And Mr. A. N. Ahmed, learned advocate for the respondent. The Union of India, Mr. Chakravarti, the Union of India. As a the petitioner / Union of India has posed a challenge to the judgment dated 23/5/2025 passed by the Central Administrative Tribunal, hereinafter to be referred as Tribunal Gauhati Bench in OA number 282 of 2022, whereby a direction has been issued to the postal authorities for considering the case of the respondent for regularization of services, who is a widow and who was temporarily engaged as a Grameen Dak Sevak mail carrier bracket GDSMC on compassionate ground after her husband's death. The contention raised on behalf of the petitioner / Union of India is that regardless of the fact that the employment of the respondent was temporary / part-time under the Gramin Dak Sevak bracket conduct and engagement bracket close rules 2011 and amended and its later amendment in the year 2020. Such a direction has been made by the tribunal. It may be noted that the husband of the respondent had died in harness while working as a daily wage contractual worker under a work order to assist with the mail vans. He was not appointed to any substantive or permanent post. On humanitarian grounds, after his death, the respondent was engaged as a temporary GDSMC at Barbang branch office, and the employment order specifically indicated that it was only temporary, which could end at any time. Later, when the services of the respondent was terminated, such termination was interfered with, and she was allowed to continue temporarily till the time a regular recruitment process was undertaken by the department. The respondent continues even today on the temporary post and has spent several years thereby. The respondent had again approached the tribunal for seeking regularization of her services. In that OA preferred by the respondent, the tribunal, after quoting passages from a judgment of the Supreme Court in Jago versus Union of India and others, 2024 SCC online SC 3826, directed the central government, has directed the department to consider the case of the respondent for regularization, considering a long period of service. Mr. Chakravarti, while assailing the order of the tribunal, very fairly submitted that pursuant to the order passed by the tribunal, the matter has already been referred to the authorities for a final consideration, but is apprehensive that the conclusions arrived at by the tribunal may not be construed as a direction for regularizing the services of the respondent. We therefore, in all fitness of things, deem it appropriate to modify the order of the tribunal to the extent that the direction for consideration of the case of the respondents would be understood to mean a decision in that regard as per the law. As per the law. With the aforementioned modification in the order passed by the tribunal, the writ petition is disposed of with the trust and hope that a decision shall be taken in that regard. By the department, which shall be communicated to the respondent. Fourth.
Item 28.
No features. This petition is filed challenging the order of Central Administrative Gauhati Bench, Lordship. In which Lordship, this Central Administrator directed the petitioner corporation to pay the PRP, Lordship, where the performance related pay. The law, Lordship, the implement order is at page number 255, and it's a C, Lordship. The party is at 264, page 260.
You have heard Mr. S. Sharma, Mr. G. Sharma, Sharma or Sharma? Sharma,
So,
learned advocate for the petitioner, who has questioned the order passed by the tribunal, order passed by the CAT Gauhati bench, dated 21/1/2026, in OA number 66 of 2023, directing the petitioner slash NSIC. NSIC का full form क्या है? National Small Industries Corporation Limited, bracket NSIC, Government of India Central Public Sector Enterprise. To release the performance related pay to the respondent within 3 months. The records reveal that the respondent slash Mr. Abhijit Barua had faced a departmental inquiry in which he was saddled with a major penalty of reduction of pay by 5 stages. For 3 years. Which punishment was upheld by the appellate authority. Almost simultaneously, a CBI inquiry also was conducted against the respondent and others, pursuant to which a FIR was registered. In the meantime, the respondent superannuated in the year 2022. After his retirement, he was paid all his terminal/retirement benefits like pension, gratuity, leave encashment, composite transfer grant, etc. Some part of performance-related pay for the relevant years, ranging between 2016 to 2017, was withheld because of lack of vigilance clearance, pendency of disciplinary proceedings, and imposition of major penalty, as also subsequent CBI prosecution. In order to get the performance-related pay for the entire period, the respondent had preferred OA number 66 of 2023 to refer to BURP before the tribunal, wherein the tribunal had passed an order directing for release of the performance-related pay to the respondent without giving due regard to several of the annual circulars issued by the corporation clearly stipulating that performance-related pay shall not be admissible to employees, which would include retired employees as well, against whom disciplinary proceedings are pending or concluded with penalty. Semicolon, vigilance clearance report is not available. And major/minor penalty has been imposed or is running in currency. Sublet notice we issue to the respondent on steps being taken by the petitioner during a period of 2 weeks, both modes returnable August. Till such time, the order passed by the tribunal shall remain in abeyance.
3rd August. 3rd August. Item 29 to 31.
May I please your lordship?
Yes.
As per your lordship's last order of 7th May 2026, as my learned senior colleague has stated that they are not going to pursue with the impugn eviction notices dated 26/11/2021. So accordingly, I apprised this honorable court and I told that I sought a permission that I would take instruction from my clients. So accordingly, I held a conference with them. They are of the view that if the eviction notices are not being pursued by the authorities, they won't be pursuing the petitions at this stage.
Mr. S. Borgohain, learned advocate for the petitioners in all the cases, submits that presently there is no instruction to him to pursue these matters in view of no imminent risk of their eviction. Presently.
As the KAC is not pursuing the eviction notices, as let it be recorded, my lord.
No imminent threat. The petitions are dismissed as not pressed, with the liberty to oppose the court again in case so deemed necessary.
Obliged. My lord, can I make one submission, if your lordship permits me? Today I came across one news article today, Assam Tribune, page number 7. It with respect to, as a law officer of the court, I have wanted to bring it to your knowledge. Fake court orders used in releasing prisoners prepared inside Mizoram jail.
We are aware of it. We have taken action on that.
Today it came, that's why
No, we have taken action on that. We have got a FIR registered. All attempts are being made to bring them back to the jail, and we have also asked for fixing the responsibility. We did it last week only.
No, but today it came up. That's why, as an officer of the court.
That's a delayed report. Good that you brought it to our notice.
My lord. Obliged, your lordship.
Item 32.
Yes.
This is this petition is filed against the impugn order, my lord. It is 1970.
This cannot be done, no? No antedating promotion after so many years. It will upset the entire thing. I don't think that's. Yes, she has to act. She's the MC.
Lordship, initially I was promoted lordship on ad hoc basis. Lordship. Thereafter, my juniors were regularly promoted. Then I agitated. Thereafter, 2000, that was on 2013. Then 2015, lordship, I was promoted. The promoted lordship. I was promoted. My 2013 superseding my claim lordship. My juniors were promoted. And financial accreditation was their lordship.
Shiv Kumar sir, Sarma judgment will not apply. BSNL has its own circular. And persons who were promoted who were junior to you now are serving as chief engineer.
I'm also serving as.
You may be, but then be happy with that. You had low grades in your ACR. It did not meet the benchmark.
But-
Somehow the other later something happened
No, Lordship, as in person,
that this matter shall be heard. Akbar, the pleadings are complete. Let this case be listed in August.
One thing I have to let you know. Lordship has, on the last occasion has asked me to get one instruction. Lordship was ready to give him the promotion manner. If he covered all these, his manner entitlement manner, the promotion manner, that's manner.
Ask you.
No, that is not reflected in the order, manner. Lordship may forgot manner, but it was manner on the last order manner. Manner, it is instruction manner. If he forgoes everything manner, does not ask for his seniority, pay enhancement, then Lordship can consider his promotion backdated manner. And to that effect, manner, I was asked to manner get instruction manner. Lordship, it is not recorded, manner. It is not recorded.
We asked for it.
Yes, manner. No, manner. Yes, all right.
Why should we ask you to be so benevolent?
and Lordship asked me to, I mean, to take instruction regarding the promotion list from the my client Lordship. Whether he's, I mean, he is inclined to take promotion.
No, should have been. She
The-
might have given her submission. We will not offer this kind of a thing. This application is admitted for hearing. Is this list? In August.
4th of August,
Is this?
4/8.
Or into
18th August.
Did-
we are not with the tribunal's order. We are inclined to set it aside.
That I have understood.
But before that, we'll give you an opportunity of hearing.
Lordship.